morning, everybody. This is the Town of Sherborn Zoning Board of Appeals. It's May 31st. We have a half-hour meeting this morning to discuss the Farm Road Homes decision. These are deliberations, so public comment is not invited, but you're obviously all welcome to monitor and watch us and make sure we're doing things right. A couple of procedural niceties with which to open. I did get some emails asking whether people could remind us about items in the record that we didn't seem to be discussing. And speaking for myself, I welcome those sorts of comments. It's probably best to email them in. That way they'll be in the record and you're not interrupting the deliberations. But certainly I know Zach and Todd are young and remember everything that's in the 100-odd submissions here, but I do not. And so occasional reminders that something was submitted in September are helpful, at least to me. And I won't speak for Jonathan.
Thanks.
Second of all, timing. There is a 40-day deadline and a 14-day deadline. There was some discussion on the Greenwood Homes as to whether or not our decision had to be written, signed, and filed within the 40-day deadline. The appeals court has explicitly ruled that that is not required. We need to decide within it's exactly what you would think reading the regulations. We need to decide within the 40 days, and then we need to sign and file our decision within the additional 14-day time. So let's use our best efforts to have everything wrapped up by the 20th, but we do not need to file by June 20th with the town clerk. Okay. And I can give anybody, I can get anybody who wants the site. Okay, so since we only have a half an hour, Zach, where are you on the various items? You can have the floor.
Well, I'm truncating the meeting and I have the floor. Thanks, Rick. So I think we should just, pick one topic probably. I don't know if anyone has it. If Jonathan, you want to talk about the site control issues, if that's today, or you want to punt that for another day. I guess I'll defer to Jonathan on that one. Otherwise, I would say let's then discuss the water supply. Because I think septic's going to be a similarly long individual meeting.
I'm prepared to discuss the deed restriction.
All right,
that sounds great.
Very good. Can we spend like 15 minutes on the deed restriction, and then try to move to the water, and unless you've got something that's going to be a game changer on the deed restriction, Jonathan, and you're a smart guy. I'm glad to hear about one.
Okay, thank you.
No pressure.
All right. Well, I want to mention the record documents that I've referred to in my analysis. A June 2nd, 2022 letter of Arthur Fenno to the Select Board. A July 18, 2022 letter of the Select Board. A August 2nd letter. August 2nd, 2022 letter of Paul Haverty to Mass Housing. A August 30, 2023 letter of Dennis Murphy to the ZBA. And a September 12, 2023 letter of Arthur Fenno to the CBA. Okay, so there is a deed dated January 11, 2021 from Ionis Meolus to Phoenix Partners for the 55 Farm Road parcel, which is sometimes referred to as Lot 1. This deed makes specific reference and incorporates by reference the restrictions and conditions recited in the deed of Richard Saltonstall and D. McLaughlin Building Company, dated February 20, 1980, and recorded in the Middlesex South Registry of Deeds in book 13926 at page 211. Those restrictions and conditions, incorporated by reference, specifically provide, among other things, that number one, the parcel described as Lot 1 shall not be subdivided into lots or parcels, nor shall any conveyance or transfer of less than the whole part be made. And 2, that the above restrictions shall be considered a covenant running with the land and bind the undersigned grantee and his successors and assigns. The restrictions and conditions specifically attach to a parcel of land described as herein before described as Lot 1 and for the benefit of Lot 2 and 3. So the deed to the developer expressly prohibits subdividing that parcel and also expressly provides that that prohibition belongs to and is enforceable by the owner of Lot 3, which is the town. Now, Mr. Haverty, on behalf of the developer, in his August 2nd, 2022 letter, argues that by operation of law, the deed restriction has expired. That is the developer's position. And I find that it has no merit. The new restriction contained in the 2021 deed is in full force and effect. And the fact that it contains language that was in an earlier deed does not affect its legality in any way whatsoever. So
Jonathan, you dropped out.
yeah, I don't know if there are any more points I really need to make there.
Yeah, I mean, okay. I think, I guess when I first looked at this issue many months ago, I came to the same conclusion as you. I thought that this would be a dispositive issue. I think Rick, I guess, has sort of convinced me that maybe the prudent way to go would be to seek a DJ to resolve the issue. So I guess, I'm sort of with you, Jonathan, on your legal, interpretation of the documents and the facts. But I guess I would sort of ask Rick to sort of explain why I guess he feels that maybe it's insufficient or why a DJ might be a more appropriate path.
Sure. The problem, I think, with the incorporation by reference being a new restriction or an extension of the old restriction is that it does not account for Massachusetts General Laws, Chapter 184, Section 27B for boy, which sets forth the process for extending a ordinary restriction beyond the 30-year statute. And therefore, it's not at all clear to me, since the 27B process was not followed, that the incorporation by reference is sufficient on its own to extend, revive, or impose a new restriction. I think that would be a question of law for a court to resolve. And the related, so and even if the original private restriction by its terms would have expired in about 2010, long ago, my concern is that the 1999 or 2000 conveyance to the Conservation Commission made it a restriction owned by a governmental entity. And so that might start a new 30-year period, whether or not the process for formal adoption of a permanent restriction goes on there. So in answer to Zach's question, I think it's a little bit of a legal muddle. I hear everybody's arguments, but it's not inarguably clear to me. And that's why I would say it's fair to the homeowners to say, go get a DJ, get a ruling that everybody can rely on.
Yeah,
that's my story, and I'm sticking to it.
Okay, what is the benefit in including that as a condition, as opposed to writing a decision which takes the position that the restriction is in full force and effect, and then goes on to recite other reasons perhaps why the application should be denied?
Well,
that brings up a question
go
I
ahead.
had, if you don't mind. Is assuming the applicant appeals a denial,
Right.
does the denial, does it rise and fall fully, or is it severable, right? Or certain conditions, if in appeal it's determined that we didn't have a basis to deny on a site control issue, for instance, but we would otherwise impose other conditions, right? So is our decision, or the failure points of our decision, severable from the decision to make the rest of it stand?
Yeah, so
like with water supply, the topic that we discussed at our
Right,
last session,
right.
for
So let me-
example, I guess,
so-
right?
let me try to break that into pieces, and I'm not a hack expert, and we can go to town council if there's lack of clarity. But in general, our decisions are severable. So if we say there are 6 reasons to turn this, we're going with a straight turn down, and here are the 6 reasons why, and 4 of them get thrown out as invalid reasons. The 5th one is still valid. Now, if we were to say, this restriction is in full force and effect, I'm not sure we can go on and then condition an approval because the project has failed for site control. I think one of the reasons I'm reticent to say the site control issue is settled is it's then binary. We either turn it down completely because there's no site control, or we don't. And I don't like sending a decision off to hack based solely on the not clear to me as a real estate lawyer view of the restriction. That's rambled a little bit. Did it answer your question?
I think so. I mean, I think so. I guess trying to blend procedure and substance, I guess, or I should tease the two out. So I just need to think on it for a moment. I guess what you're saying is putting a decisive binary decision in our sort of point on the site control will, I guess, do what to the review? Will that limit the review? Or
no,
are you saying they can only? I guess that's what I thought, right? So
sure. I probably didn't answer clearly enough. Let's say we're turning this down for site control, and that's it. That makes a very short decision. It's easy to draft. And it goes up to hack or from hack into court, and the decision is reached by a court of competent jurisdiction that the restriction was no longer in effect, and that our board invalidly turned down the project based on lack of site control, based on a now expired title restriction. Then the developer would be able to argue that it was deemed approval the way it was put in front of us. And I don't like that. I would much rather have a decision where, to the extent that part of it gets knocked out, the other conditions could stay in place.
Can we write in our opinion? I mean, I guess that's the question, right? Can we write our opinion that way to say, like, we do feel that site control is determinative and dispositive. However, in addition to that, we find other reasons, or we would otherwise, if for some reason that fails, just state it. And then say these are the other conditions that we would also impose on the project to the extent that is, appealed.
Yeah, I can talk with town council about whether we can do that sort of alternative analysis.
Yeah,
I think to your point, because I think, I guess it's a procedure, at some point this issue has to be resolved. But if we could make our position clearer as well as impose conditions, and if in fact that position failed, then that would, I think, be the ideal path. Okay. Jonathan, is that what you're trying to get at?
I think so. If I'm hearing you correctly, Zach, what you're saying is, listen, ideally, I'd like to say we're turning this down for lack of site control. However, to the extent that's not an invalid ground, here's what we would do about public water supply, septic, and everything else.
Yeah, it's just taking a firmer position, I guess.
I think we're.
Go ahead. Go ahead, Jeff.
I think we're all in agreement that there is. Sorry, Jonathan.
No, you go.
Okay, thank you. I think we're all in agreement that there is something here around the deed restrictions that requires clarification. I've heard a couple different interpretations as the non-lawyer here. I'm inclined to believe that there is something here, and we need some clarification on it. What I would be leery of is, to use a non-legal, non-technical term, I don't want to get cute with what we draft here, and I don't want to cheat ourselves in the town and public health and safety out of us fulfilling our mandate here of reviewing and articulating our position on all of the other topics that clearly are weighty in this matter.
Yeah. Totally agree with that. And now we're talking about how to thread those shoals, as we voters say.
Yeah.
Yep.
Jonathan.
So, no, I absolutely agree. I don't want to turn down this project waiving any reasons why we would turn it down. And so I am concerned about the issue of waiver. I think we ought to write a decision that firmly expresses our position based on the facts and the law. And maybe town council can help you with this, Rick. I don't think that the restriction issue is a jump ball. I don't want to send off the impression to the courts that we don't know, that we don't have a position on it.
Yeah, okay. I'm with you on that, because I don't think it's a jump ball either. I've been a real estate lawyer to feed my family for over 40 years. And I will tell you that if my client was trying to buy this property and develop, I'd say, don't, over just this issue, until somebody comes to you and resolves that held by the conscom issue, just don't pay any money for it. It's just not investable. It's not marketable. But if the client said, okay, great, now bet your license to practice and your firm's retainage under their big malpractice policy that it's absolutely positively going to be held valid, I'd say, I don't think so. I think I'd like a judge to do that. Is that a fair answer to your question?
Yeah.
Yep.
Okay. So I don't think it's a jump ball either. If I were to forecast it right now, I think the people seeking enforcement of the restriction are somewhat more likely to win than the applicant. And, Jonathan, if jump balls are 50-50, my thought is it's probably a 65-35, maybe a 70-30. It's not a 95-5 in my view, but I'm just a poor dumb deal lawyer. You litigators are the smart ones who can predict judges.
Well, nothing's 95.
Yeah, not in the litigation world.
Yeah.
Okay. All right. So is our position on the restriction that I should go back to town council and see if we can do this sort of alternative disposition that Zach was describing, which I would recharacterize as, we think the restriction makes it a fail under site control, but to the extent that it passes site control with the following additional either reasons for turn down or conditions if we approve it.
Yeah,
I think that would be prudent.
Yeah.
Okay. I will ask.
I
bet
appreciate everyone sharing their additional insights. As a non-lawyer, sometimes it's difficult for me to read between the lines of the positions that you're taking. So thank you for the additional color this morning.
Well, we thank you for being a non-lawyer, because sometimes lawyers go a little too far down the rabbit hole and don't realize that we should be out in the light and not chasing the rabbits. Okay. 11 minutes left. Do you want to at least start on public water supply a little bit, Zach? Or
sure. I guess you had mentioned that we required that the board had, I guess, influenced a public water supply in a previous project, and so I'm just curious. Do we have was that an agreement by the applicant in that situation, or do we have the authority to enforce a public water supply here? I guess
it wasn't a matter of clear authority. We hereby decree that thou shalt have a public water supply. We expressed grave reservations about the public water supply based on what the Board of Health and what our outside consultant which was Nobis, who was supplementing the peer reviewer, and I forget the peer reviewer, but I don't think it was Tetra Tech. And ultimately, in the course of negotiating a whole bunch of things, including the septic system and some site design issues, the development team said, no, we're changing to a public water supply.
I see.
So,
So from a procedural standpoint, do we have a tool or a lever to influence that here with a condition?
Sure.
Is that enforceable? Yeah,
Sure,
is that an
well-
enforceable condition? I mean, I don't know. That's the
Yeah.
question, right? Can you condition a significant modification in that regard?
well, if what we're trying to solve is a legitimate health and safety problem, go back to the Stowe case.
Right.
We can turn down the project for legitimate and real health and safety problems. If we think that private water supply does not meet the legitimate health and safety needs of the town, we could say we're turning down on that, but we would approve it if you change to a public water supply.
I mean, that's my position based on all the evidence all the information that's been submitted to the board in this matter, as well as I think importantly the experience of nearby residents with the hybrid system, which has been I would say not ideal in their experience in ownership experience, and this is a larger project. And there's, I guess, less margin of error, in my opinion, or not even comparing the two. There's just not a lot of margin for error here with the assumption. So I think a public water supply really is prudent.
Okay, and I was trying to toss my file in a constructive way, as in go through it, not throw it out. And I hadn't yet found Tetra Tech's position on the public water supply. My recollection, I want to go back and look at what they said, was they didn't take a strongly held view one way or another. What do you guys recall? And we can look it up. That's the beauty of writing things down is, you don't have to recall things. But unless Tetra Tech said something, let me put it this way. If I go back and find that Tetra Tech said something very unequivocal, saying that they thought the private water supply worked, it's not my recollection, but let's go read what they said. Unless they were really clear that they thought it worked, I'm very much with Zach that on balance, the redundancy, the safety, the other aspects, I just am not persuaded, particularly when it did not work as well as forecast at Abbey Road. And there's going to be way over 25 people here. And that's, it just makes some common sense. So if Tetra Tech said unequivocally, we think it's a good idea, I guess I'd think a little more. But unless they said unequivocally, we think the private is a good idea, I'm with Zach on lobbying for the public. Where, Jonathan, Todd, where are you guys?
Well, I also agree with Zach.
As do I.
Okay.
And you.
I appreciate that. So is our tentative working assumption that we're going to say we do not approve the private water supply as proposed by the applicant, but we would support a redesign based on a public water supply?
Yes.
Yes.
Again, assuming that redesign passed all the other hurdles. Okay. We got 6 minutes left. Do we want to even talk about septic, or is that's a long topic? Let's discuss that at our next meeting, I guess.
Sure.
And I guess I would suggest to the group the homework of continuing to review your files, freshen up on septic. If somebody has a new showstopper on the title restriction, I'm willing to hear it. But I think otherwise we've got all the puzzle parts out on the table in front of us on restrictions. And on public water supply, let's all take a look at what Tetra Tech had to say and think about if that's sort of our final answers, they used to say in that TV show. I think it's my final answer. I just want to go through Tetra Tech's comments and the other comments one more time.
Makes sense.
Sounds good.
All right, in that case, in order to give Zach a few minutes for a bio break, we could entertain a motion to adjourn and continue our discussions at 8 a.m. on June 4th.
Sounds good.
Yeah, I second that motion.
All right, and Jeannie, you'll send around a Zoom invite for the 4th, please.
I will. I've already got it set.
All right, everybody, thank you for your attendance today. And again, if you think there are issues that we should be discussing that are in the record, please send an email on that. I guess one of the questions was, could we take judicial notice of things that aren't in the record but are public matters? And Jonathan, you're the litigator, but I think, you know, if it's a case, a statute, a ruling of a judge, something that's clearly out there, I think we can take judicial notice of it in our quasi-judicial role. Someone says,
Yeah.
great, I've got a new 50-page report on traffic. Forget it. That's out. The hearing's closed.
Right.
Okay. All right. We're off till next time. Thank you, everybody.
Thank you.
Have a good
Thank
weekend.
you. Have a nice weekend. Bye.
Thank you. You as well.